So I'm so excited to have Kendra here. And since 2011, she's been focusing her legal practice solely on estate planning and advanced estate planning, specifically the legal work to prevent probate. As a San Mateo County native, Kendra obtains great satisfaction using the law to help other San Francisco Bay Area residents and homeowners avoid the time-consuming, costly, and disruptive probate process. She graduated from Hastings College of the Law and U.C. Davis and guides fellow residents through the estate planning process in a fun and efficient way. Her creative and positive approach ensures that each client makes the right decision given their estate and family situation. While performing thousands of estate plans, Kendra has successfully worked through nearly every possible family and estate situation, including her own journey with her now 2 deceased parents. Most clients comment that the estate planning process is much less of a chore than they thought and are very happy they elected to work with Kendra to get their affairs in order. So we're so grateful for you being here, Kendra. Thank you so much. I want to tell everyone that we will be having time during this training for questions. Some of the questions, if they're really personal to you, we'll be sure to put in information about how you can get a hold of Kendra through HERA. So it's more, we'll be taking more the global, broader questions and put them in the chat as they come up, and I'll log them. And when we have our moments to do questions, I will share them with Kendra and we'll answer them as best as we can. Thank you so much, Kendra, and take it away.
Good morning, everyone, and thank you so much for joining us today. Wish I could be there in person, but this is the best that we're doing in these times. So again, thank you for carving out some time in your day to join me and discuss a very important topic, which is estate planning. Like Beth said, we're going to have a couple of breaks for questions as I roll along. So please just make note of those. And then about halfway through the presentation, I'll stop and answer questions about the first half. And then towards the end, I'll answer any questions that you've had for the entire presentation. Our presentation today is going to essentially cover 2 types of issues, 2 types of legal documents that nearly everyone needs. So the first part of the presentation is going to be really, and it's not the most pleasant thing to talk about, but what happens if we were to pass away? What kind of documents do we need to have in place in order to protect our families? And then the second half of the presentation is going to cover issues and documents that we need while we're living. But let's say we just had a situation that occurred that caused us to be temporarily incapacitated. Let's say we were in an accident or had an illness which caused us to be in the hospital for a couple of months. So we want to make sure to have documents in place with respect to healthcare issues and financial issues so that when we hopefully get better, things will be as they should be in our lives. So I will start sharing my screen with everyone. All right, here we go. And I'm an estate planning attorney with HERA, the Housing and Economic Rights Advocates. We do a lot of things to help preserve people's homes and home ownership rights. And so it's just kind of natural that we started an estate planning department here so that homes would transition to hopefully the next generation without a lot of chaos and unnecessary expense, which can take place with a probate. But to catch up a bit. So with estate planning, things that we're going to think about are the what, the who do we trust in our lives? When do we want to have certain things take place for our kids if we were not there to make that happen? We're going to discuss why we need estate planning and the wheres. You know, where do we own property? Where do we have assets? Okay, so we're going to first go through several misconceptions, or maybe not misconceptions, that people sometimes have. So some people think, I don't own a home, I rent, I have no assets, I don't need estate planning. Well, that is false because you have yourself. And like I said, the second group of documents and legal issues concerns what would happen if we were alive but incapacitated. So if you were in the hospital, you would want to make sure that you have someone in place to advocate for you and make good medical decisions for you on your behalf. Also, if you have a bank account, you would want someone to have legal authority to pay your bills. So even if you don't have anything right now, you still need certain types of estate planning documents, and we will get to that shortly. Another misconception is people think that things will naturally just go to their kids if they were to pass. Oftentimes that will happen, but it will do so through a very messy process called probate. It's expensive. It takes at least a year and a day. We really want to avoid probate and not put an extra burden on our families if we were to pass or if something was to happen to ourselves. In estate planning documents, you can provide that if you do have older kids, and let's say you have a child who really is making poor decisions for him or herself, you can provide that money is in a special needs trust sometimes for one child. You can make an unequal distribution to your kids. It's really whatever works for your family, as long as it is in a notarized, properly executed estate planning document. Your intentions will one day take place as long as you have put a little work into it while you're with it and doing well to make sure that's evidenced in writing. Another big misconception is people who have taken the time to create a will think, I have a home, I have a will, this will avoid probate. That is false, because in California, if you own assets totaling over $166,000, even if you have a will that instructs where your property is going to go, there will unfortunately be a probate of that will. The probate courts don't care if there's a loan against the property or not. It's just very clear. If you have assets that total in the aggregate over $166,000, even if you've directed where those go through a will, there will be a probate. And we'll get to ways to avoid probate shortly. If you have a living trust and you have properly funded the trust, which means taken the time to put your bank account into the trust, put your real property into the trust, there will likely not be a probate. If you create a trust, let's say yourself, and just don't put any assets into it, there will be a probate because it won't apply to any assets of yours. So a living trust is a very good way to avoid probate, but you have to follow the instructions per that trust and put assets into the trust. And then another big misconception people have is we're a very tight family, the kids get along great, there won't be a problem at all when I pass, they'll work it out. We have probably all seen the little horns come out when something traumatic happens to a family. So it's much better to take active steps now to prevent chaos, disputes, spouses getting into the mix by executing proper estate planning documents so that the kids will get along well when you're not here in order to help that process. Okay, so estate planning is the process involving the people in your life and your property, and it addresses needs now. Let's say, once again, you got into an accident or there was a medical situation that took place which caused you to be in a hospital. So it will address things that could happen now or in the future when you pass one day. We'll just do a little review of estate planning documents, and it's okay if you really don't understand these documents, but since we're going to first discuss what happens when we're alive and what documents do we need in order to handle situations that can come up while you're alive, we have healthcare directives, because we do have healthcare issues that come up when people are alive but can't make good medical decisions themselves. And then on the top, we have a durable power of attorney for financial purposes. That's a document important while you're alive, but if you did not have legal capacity to, let's say, file your taxes, to advocate with the county recorder's office if they were going to raise your property taxes. And in the same vein, the revocable trust that you would create if you were a homeowner would cover trust asset issues and have someone in place to handle those if you were incapacitated. One day, hopefully a long time from now, when you pass away, any trust you create now will become irrevocable. So no one can ever change that trust. They just have to do what you've stated in that trust. And then you'll have a will. You'll notice that the other two documents don't carry over beyond the date of death. That's because a power of attorney and a healthcare directive become void when you pass away, and it's only the trust and the will that kick in at that time. We're going to talk about each of these documents in more detail. I've covered this, but once again, estate planning is for any incapacity now, temporary or permanent, and then it's for planning when you pass one day, deciding who should manage what you have and distribute it according to your terms, and when that should take place, given the ages of your children. Okay, we're going to first delve into probate and why we need certain documents to handle what happens when we pass away. So in California, as I mentioned earlier, if you own assets totaling over $166,250 and you do not have those assets in a trust, nor do you have beneficiaries on those assets. So you might have an account with some money in it, or you might have a retirement account with some money in it. And if you place beneficiaries on those accounts, that avoids probate. So we're talking about assets on which you cannot place beneficiaries, which are usually pieces of real property or a home. So if the gross value of those assets total over $166,000, there would be a probate to distribute those assets when you pass away. So holding assets in a trust avoids probate. In California, they're trying out this transfer on death deed, but if you do get a form and put a beneficiary on the bottom of a very certain kind of deed per a lot of restrictions, that can avoid probate at times. As I mentioned earlier, putting beneficiaries on an asset, which can sometimes be called a POD account, payable on death account, that can be a way to avoid probate as long as those beneficiaries are alive when you one day pass. There does not need to be the probate process to distribute a POD account as long as that beneficiary designated there is alive. What happens at that point, frankly, at the time of death, is someone gives that bank, that entity, an original death certificate, and they will issue a check to your beneficiary on that account. For certain pieces of real property, if you hold it as joint tenants or as community property with right of survivorship, if one person on that deed passes, the other person can take the whole interest in that property without probate. The problem is, let's say 2 months later, the last person standing passes away, there would be probate then. So if you are in the situation where you own property because a joint tenant or your spouse passed away, you need to definitely put that property into a revocable trust to avoid probate, so that one day that property or the interest in it will go to your children. In the same regard, if you own property and it's going to go to your spouse or domestic partner, you typically don't have to go through the big messy probate as long as it's a registered domestic partner. And with retirement benefits, like we stated earlier, if you have beneficiary designations on your retirement accounts, that will avoid probate because it's a beneficiary designation, as long as that beneficiary is alive when you pass away. So if you are a homeowner, the best way to avoid probate one day is to create a revocable trust and put your home into that trust. Typically, a lawyer would do this for you. When you do this, you'll notice that you, as the trustor, settlor, grantor, will have many names in the documents, but essentially it comes down to the fact that you are the person who gets to decide everything. You can change your documents whenever you want. You own everything and you are accountable to no one. You're not even accountable to your beneficiaries down the road. When you pass one day, a person chosen as a successor trustee, whose job it is to dole out the assets to your beneficiaries, he or she will be accountable to to those beneficiaries about what he or she is doing. But you, as a settlor, grantor, trustor, have no accountability to anyone. You can sell it, spend it, it doesn't matter. So once again, realize that if you create a trust and put your home into the trust, you still own your property. It is still all yours and you are free to do whatever you would like with that property. So we're going to look at a trust versus a will. And once again, a trust is necessary if in total you own assets that are over $166,000. If you own a home worth $600,000 and there's a $500,000 mortgage against that property, the court doesn't care. There would still be a probate to transfer even that $100,000 interest to your children one day. So if you own anything in the aggregate that totals over $166,000 on which you can't put beneficiaries, then you will need to have a trust. So with the trust, no probate is needed. Another aspect of having a trust that people like is that it's private. When you pass away one day, the trust is not filed anywhere. You'll look on the other side of this slide. A will is probated and a will has to be filed at the probate court. So anyone who can do a little bit of research can find out where your stuff is going to go. With the trust, it will always be private. It's a private family document. With the trust, there are no guaranteed fees necessarily to the successor trustee or to their attorney. Sometimes when people pass via a trust, and when there's a trust in place, the successor trustee doesn't need to even hire an attorney. They can really do the work themselves. So your family will save a lot of money in that way. With a will, there's statutory compensation, and typically the executor and his or her attorney will pay themselves quite a little bit of money, and we'll look at a chart shortly. Assets in a trust are not subject to estate recovery. So if there's benefits paid by Medi-Cal, they will not go against typically assets in a trust as long as there was no fraud. They will go against assets that are subject to probate. So that could be an important difference. And probate and a will just takes more time, more money. Administering a trust can be done in a shorter period of time. It really doesn't cost your family much. So there's a big difference. For those of you who don't feel like you're going to purchase real property down the road and just realize, hey, I'll probably always be under that $166,000 figure, you don't have to only distribute property through a trust at death, but if you're under that figure, you can't distribute your property through a will. There's not going to be a major probate needed when you pass away. So preparing a will at least will designate who is going to get whatever you happen to have at that time, your car, a little bit of money in your account. You can execute a will to make sure that does take place. But if you even anticipate that you're going to purchase a piece of real property down the road, it's probably good to consider having a trust created. And once you buy that home, a title company will put your home into the trust for you. Probate, I've touched on this a bit. So probate is the court supervised process for transferring property either without a will, through intestate succession here in California, so to your spouse or kids or whatever it would need to be, or supervising the process through a will of distributing property. The probate fees are essentially there to pay the court for overseeing the distribution of assets at death. And once again, a trust doesn't need to be overseen. And the check and balance there is that the successor trustee of a trust is accountable to the beneficiaries of that trust. So there is a check and balance there. If someone passes away and does not have a trust and does not have a will, there is a mechanism in California. Typically, assets will go to a spouse, children, if there are none of those individuals, grandchildren. If none of those people exist, parents. If parents don't exist, then to brothers and sisters. So California will decide where your property is going to go at death if you don't take the time to decide that for yourself. So if you don't have kids or a spouse or parents, this might work fine for you if you would want everything to go to your siblings equally. But if you don't, you need to take the time to make an unequal distribution yourself. And that's what will happen when you pass away one day. And this is just another chart that kind of shows how how distribution will take place if you haven't taken the time to decide that and evidence that properly yourself. So if your family or if you have assets over $166,000 and you do not create a trust or designate beneficiaries on those accounts, and your family does have to go through probate, this is just a little bit of the types of things that your family is going to have to hire an attorney to do. They're going to have to publish notices, mail notices, file a bond, prepare an inventory, give it to the court, give notices to all the creditors, appear for a hearing, file accounting to the court. So there's a lot of administrative things, and that's why probates are expensive, because you're paying an attorney to orchestrate this and you're paying the court to oversee this process. And we want to avoid that because it's very easy to prevent spending all this money on an attorney into the probate court down the road by creating a trust or putting beneficiaries on accounts. These are the statutory fees that California had to put in place because attorneys were frankly charging too much to probate estates. So let's say you own a home, let's say it's worth $800,000. The fees to your successor trustee will be $19,000, and then the fees to his or her attorney will also be $19,000. So that's a lot of money off the top prior to any distribution. These individuals will make sure that they are paid, and they'll pay the bills of the estate, and then they'll make a distribution as to what's left over. So we want to once again avoid these high fees. These fees frankly don't even include filing fees, the advertising fees where you have to run it in the paper, any extraordinary fees. So it can be well above this, depending on the attorney that would be handling the probate. Okay, so we're going to do an example of what would take place if there was a probate versus a trust administration. So the gross value of the estate is $1 million. We're talking a home and then, cars and some other accounts. Let's say there is a $300,000 mortgage against the home, so the net value of the estate, and we're doing the trust administration side first, which is on the left. Let's say there's some cost for administration. Let's say the home's going to be sold and they need to have some work done before they put it on the market. So the cost of administration is $20,000. So the balance that will be distributed at the end of a trust administration, as long as an attorney does not need to be hired, can easily be $680,000 if a trust was in place and a home was put into the trust along with a couple of accounts. Let's look at the probate administration side. So once again, the fair market value is $1 million, and there's a mortgage against this real property of $300,000. The net value left is $700,000, and they're still going to have to do some administrative work, bringing the total down to $680,000. But the statutory fee to the executor is around $23,000. And then the statutory fee to the attorney is $23,000. And like I said earlier, there may be some extraordinary fees to either of them. The balance that will eventually be distributed is going to be almost $50,000 less than if they had had a trust in place. So $634,000 would eventually be distributed to these kids here. This would have been very easy to prevent. The spending of $46,000 could have been avoided if the parent had created a trust and just put the home into the trust. So we're going to do a little scenario here. So let's say an individual, Pamela, died, and she had the following assets: a house worth $300,000 titled Pamela Anderson, trustee of the Pamela Anderson Revocable Trust. She has 2 retirement accounts and has a beneficiary on those accounts. She has life insurance. Her mother, Stella, is the first beneficiary on the life insurance, but then she has her brother as a secondary beneficiary on her life insurance policy. And then she has some other accounts totaling about $2,000, and her boyfriend, Tommy, was placed as a beneficiary on those accounts, the checking and savings account. Do you all think that there would be a probate in this situation or not? You can look to see how things are titled and what she's taken the time to
Just
put in
type your
place.
answer in the chat.
Yeah.
So repeat the question, Kendra.
So in this scenario, looking at how Pamela has titled her assets, a house in her trust, 2 IRA accounts where she has named Ben as a beneficiary, life insurance policies where she's named her mother as the first beneficiary, who's unfortunately died, but she did take the time to put her brother Leo down as a secondary beneficiary. And then the last asset she has are a savings and checking account where she has put her boyfriend Tommy down as a beneficiary.
Okay, we have lots of no's, a few yeses.
Okay.
The majority of no's.
Okay. Good job, everyone, because you will see that she has properly handled all of these assets that she has. The house, she created trust and put her home into her trust. The IRA accounts have a beneficiary who is alive on those accounts. The life insurance policy, she took the time to put a secondary beneficiary down who is once again living. And then on her checking and savings account, she was specific and put someone's name down on a beneficiary of those accounts. So there will be no probate here. She will not have to hire an attorney. Everything will seamlessly go to whomever she has stated in her trust or according to the beneficiary designations indicated here. Her brother Leo will receive life insurance and Tommy will receive her checking and savings account worth about $2,000. Okay, so we're going to do another one. Let's see. Okay. So let's look at another scenario. So Alex passed and he has a house worth $300,000. It's in his name as an unmarried man. He has 2 retirement accounts, 2 IRA accounts, but he never took the time to fill out the beneficiary form. So no beneficiaries designated on those. He has life insurance of $70,000, similar to Pamela's policies, but he put his father down, but he never took the time to put a contingent or secondary beneficiary down. And unfortunately, his father died and then Alex died. And then on his checking and savings accounts, he just put my girlfriend down as a beneficiary. And apparently 20 people are coming out of the woodwork claiming to be his girlfriend. So in this scenario, looking at how assets are titled and what he's done with respect to beneficiary designations, do we think that there will be a probate in this scenario?
And most people are saying yes, absolutely, yes.
Absolutely correct. Smart crowd.
Yeah.
You're right. So the house is just in his name. Maybe he planned on creating a trust down the road and was going to fund the trust with his house, with his interest in his house, but he never did that. He didn't take the time to fill out those beneficiary forms. The life insurance policy where he did complete a beneficiary form, he never took the time to put a secondary beneficiary down, and unfortunately the first name beneficiaries passed, and then the checking and savings account beneficiary designations are way too vague. So in this scenario, there'll be a probate for everything. So his family will have to hire a lawyer and go through the probate process. Okay, so we'll talk a little bit about the transfer on death deed, which we have here in California. It kind of started out to be an experiment. To me, it is a way to designate a beneficiary if you're kind of in a rush. I've had clients who have surgery and they don't have time to get their trust done. They admit that they procrastinated. So if they have a simple beneficiary designation that we can indicate on a transfer on death deed, we can just put 1 or 2 children down as a beneficiary, and that will work. You can use this form if you have a single home or if you have a fourplex. Anything beyond that, this is not a tool to indicate a beneficiary. One thing that's kind of difficult about this document is oftentimes in a trust, people state hey, when I pass away, everything's going to go to my 2 kids equally. If something happens to one of my kids, I want their 50% share to go to their children. You can't do this on this document. So it's basically, if you put 2 kids down as beneficiaries, if one of them happens to pass, it's just the property will go 100% to your surviving beneficiary indicated on that form. And oftentimes that does not reflect what people would really want to have happen. So you can use a transfer on death deed. You just have to be aware that it's sometimes not the best tool to get you where you want to be with respect to estate planning. And here's a sample of it. So you could always pull one down if you really just wanted to get something done in a very short time frame. Another common question that comes up, people think that they can avoid doing a trust by just adding a child to a deed. One thing to keep in mind is that if you add a child to the deed, if that child gets married, if they get into an accident and don't have like an auto accident, and if it's their fault and they don't have good auto insurance, your asset will be liable for that debt. If they file for bankruptcy, that asset, that home on which their name has been placed, will be subject to that bankruptcy. So in general, we don't recommend putting a child on title to a home. It can also affect the basis, so how much capital gains tax might be paid down the road. So once again, it's something you should really talk to your accountant or tax person about, or to an estate planning lawyer about. Okay. Okay, so it was a lot of information. We're going to take a little break here for me to answer any questions that you have about the first half of the presentation concerning what happens when we pass one day.
Great, thank you for that. And there are questions. One is, does a trust supersede community property laws?
It does not supersede community property laws. So if I have a client who comes to me alone, but they're married, even if they've been separated, and their deed states that they own their house as community property, I can't have one spouse just decide, oh, I'm just going to put it in a trust and sever that community property, because community property is ingrained, state law. So that spouse would have a right that would essentially trump anything that they've done thereafter in a trust. Okay. Now, a trust could affect separate property. So if you had assets prior to marriage and you want to put them in a trust, there wouldn't be much of a problem with doing that. If you had your own assets that you had inherited while married, or you had your own assets that you owned prior to marriage. Okay.
All right, hopefully that answers that question. And then here's a question. What happens when someone has a trust and they die? How do the people, I guess, get their property, or if they're going to claim the property? I think that's all in the trust, isn't it?
Good question. So when someone passes away, well, hopefully prior to that time, the decedent has let someone know that they have a trust, and when I pass away, you're going to find a copy of it, or here's the attorney's card. He has a copy of it at his office. And so when the person passes away, someone will find the trust or be alerted to the fact that there is a trust. When the trust is reviewed, there will be beneficiaries indicated in there. So the trustee needs to send a copy of the trust to all the beneficiaries. Also, let's say there's a natural heir. So let's say a child that was disinherited in the trust is not a beneficiary, but is a natural heir. A copy will need to be given to that individual as well. Those individuals have 120 days to object to the trust. Usually doesn't happen. And then the successor trustee, let's say there's a home, will need to file the original death certificate with the county, along with an affidavit of death of trustee. That will allow that next trustee to do whatever he or she needs to do. Maybe it's sell the home, get the money, pay off the loan, and distribute the proceeds to 3 kids equally. And then that trustee will execute checks to each of those individuals, would have the kids sign off that they've received their full distribution. Typically, those kids will be provided an accounting. This is how much I sold the home for. These are the bills I had to pay. This is how much is left. So it's pretty seamless at that time.
Okay. And I would imagine there's a lawyer that sort of helps walk people through.
Yeah. I mean, sometimes there is, but if the person kind of has the time and wherewithal, they can do a lot of it themselves. But certainly, usually that person's lawyer will help if needed.
And then how do children who are minors play into a trust?
Yeah. So if I have beneficiaries who are minor kids under the age of 18 or, well, in the trust and the will, guardians will be indicated. The guardian is the individual who would take care of the child if you were to pass away. So that's the home in which the child would live. It doesn't have to be the person who's in charge of the money, because in the trust, it will say the successor trustee will invest the money, use the money for the health, welfare, education of my child, pay bills for college, whatever needs to be paid. And then at age maybe 21, 25, whatever you are comfortable with, and whatever age makes sense for your child, you will decide that prior to your passing, so that the successor trustee, once again, will use that money, whatever you have left in your estate, for the rearing of that child, college expenses, etc. And then the balance, if there is a balance, will be handed over at the age that you have chosen. So 21, 25. But the money will not be given to the child until that age that you have chosen is attained. So
Great.
you have someone overseeing that process. That's why your choice of who you would like to oversee that process is very important. You have to be very honest in analyzing the strengths and weaknesses of the people in your circle.
Wonderful. And someone has asked, a couple of people have asked about developing or drafting a trust themselves, or do they need a professional? And I'm just going to give a plug for HERA. I know a number of our staff at First Five have used HERA services. So if you don't want to do it yourself, and I'm not sure even if you can, Kendra.
Yeah, people, I think it's much better to go to an attorney, because basically the problems that we see is someone has, and of course we always see it when it's too late, when someone's passed, but someone has gone into, let's say, Rocket Lawyer and created a trust, but they haven't put their stuff in the trust. So it's a document that frankly doesn't apply to anything. So there's still a probate because the house was never placed in the trust, or accounts were never put in the trust. So a lawyer will typically take care of that funding process for you, of preparing a new deed, having you sign the deed when you sign all of your trust documents, filing the deed for you to make sure your home is in the trust. Legally, you can create your own trust. You just have to sign it with a notary. It needs to be a notarized document. So it has to be executed with that formality. But okay, especially for a married couple, it can be a little trickier too. A single person could maybe create their own trust, but it would be a little tricky making sure that you're properly funding the trust with your real property.
Okay. And how is the trust cost calculated for the estate planner's fees? So,
well, a lot of attorneys have a flat fee. Some attorneys will charge by the hour, and we at HERA, we have flat fees. It's based on last year's income. So the fees can be calculated either on an hourly basis or on a flat fee basis.
And someone's asking specifically about your rates. I don't know if you want to offer that, or?
Well, yeah, so it really depends on what your gross income was last year. So we just ask clients to provide, proof of income, and then we calculate it out on a sliding scale. Our fees are, I would say, 25 to 50% of private practice in general.
Okay. All right, great. Some other questions here. What if property purchased after marriage, but a spouse isn't on the deed? Can that property go into a trust?
Well, it can go into a trust, but it depends on what should probably happen. And perhaps this is what the person intended. For some reason, they were buying a home and didn't want one of the spouses on the deed, maybe bad credit or something like this. So you would go to an attorney, bring that deed. They would first have you, they would have you sign the deed over to the marital trust. There's certain benefits of doing so. So that's probably what would happen. If you wanted to keep that property separate, you would need to probably execute a different document, like a post-marital agreement stating that both parties agree that this property shall be the separate property of,
Right.
spouse one.
Okay. All right. And then we've got a number here. When should you update your trust?
There's no magic number, but I say look it over every couple of years and make sure that your choices there are still working for you, and those people on board to take over one day are still in, pretty good shape to do so, and that you still have the same high regard of those individuals that you've chosen. So every several years or so, and just make sure once again that if you've acquired something new, let's say you sold an old house and purchased a new one, make sure that you put it in the trust. If you haven't, if the title company didn't, it was a rush and you forgot that you had a trust, it's easily fixed as long as everyone's alive and has the capacity in order to just have a new grant deed prepared and place that new asset into this trust.
Okay. And another question is, can a trust protect against any property liens?
No, it can't, because a very common question, but if you have complete control of this asset, it is yours. You just are on title a little bit differently than before, but it does not provide any creditor protection. Basically, the law sees it. If you can get to your assets, your creditors can too. So since it's still yours, 100% yours, it would still be subject to any claims of creditors.
Okay. And any thoughts about a trustee? Should they be a non-family member or a family member?
Yeah, most commonly it is a family member. It's just really whatever works for you. I mean, if your good friend is an accountant and very good about getting things done, and the people in your family are not like that, that might be a great choice if she's willing to act in that capacity one day. Mm-hmm. So yeah, it just really depends. Just be very honest with yourself when you're thinking about those roles, because you could have, let's say your sister's a nurse and she's great with medical decisions, but not so good about paying her bills on time. So she could be the #1 choice on your healthcare directive, but she does not need to be, the second alternate trustee of your trust. So you can have different people for different roles in your lives.
Okay. And I'm going to ask this one last question about, do you make a trust before you buy a house?
It doesn't matter. Making it before allows you to give a brief version of the trust to the title company, and the title company, upon purchase of a home, will automatically put title of the new home into your trust for you. So that's fine. If someone comes to us with property that they currently own, we charge a couple $100 to put that home into this trust, just because it's work and filing stuff at the county. But if you do it beforehand, it just kind of saves you a little bit of money too, from having to convert what you have to the trust. So right. Either way.
Okay, that's great. So there is one pretty very specific question, and I think it's the kind of question where Leah just put your information about HERA in the chat, that we really can't do a lot of personal things or individual specific questions. So please contact HERA. Yeah, so I think we should go on to the next one. And there are a couple of other questions, and if they keep coming in and we have time at the end, we will get to them. So thank you.
Okay. Yeah, thanks everyone. Good questions. All right, so now we're rolling into situations concerning you're alive, but you're somehow compromised. You're going through a tough time medically, you're taking medication that affects your abilities, or you got into an accident and you're in the hospital and you can't get out in order to physically do things that you need to do. So we're talking about the durable power of attorney for financial purposes and the advanced healthcare directive mostly. So we're going to start with the healthcare directive. So on a healthcare directive, you can choose how to define incapacity. So you can decide that just your primary care physician can say, Sue Jones is unable to take care of her financial affairs, and then your next person would be given the go-ahead to pay your bills for you, to file an extension for you on your taxes, to do that. You can also choose to have a panel. So you can say, 2 doctors would need to state that I lack capacity, or 2 doctors and my sister would need to make that determination. So you have control over how you would be determined to lack capacity and for this document to kick in. A good healthcare directive will not only name an agent to make decisions for you and implement things that you have decided for yourself, such as if you're in a coma, do you want to have a lot of things done to you? If it was frankly looking very bad, doctors were saying you're never going to get better. If you were to get better, your life would be severely compromised. So anyway, you have control about those medical scenarios. And frankly, in our healthcare directive, we have a provision that says, hey, if I'm in a coma blank number of days, I don't want to continue in that way. So you're going to be able to give thought. It helps because you're not putting the entire burden on the people indicated in your healthcare directive. But if you can give some thought to those medical situations now while you're feeling good and you can give time to this, it's not an emergency, it makes it easier for your next people to implement things that you've decided for yourself. It's a lot to put on people to completely make all of those decisions. You might have said one thing to someone and that contradicts something that you said 5 years later to someone else, and that can cause a lot of chaos within a family. You can indicate if you want to, if you had a bad disease, if you would want to be in a hospital, if you just want to stay at home and have care there. So you really get to control how you want any end of life decisions to take place. Oh, let me go back here. Another provision that's important to have in a healthcare directive concerns Alzheimer's and dementia. So oftentimes people who have those conditions aren't necessarily hooked up to machines that are helping them live. Oftentimes they're just in a bed and they don't have good quality of life. They're eating and drinking. Sometimes those people take control by just deciding they're done with the process. They don't want to open their mouths to eat anymore. So you can have a provision stating that if that's your only way to communicate down the road, you do not want to be force-fed and with food or hydration. So once again, your healthcare directive can be very specific and allow the end of life to take place in the most graceful manner possible for you. So that's the healthcare part of the documents that are important while you're alive. With your power of attorney for financial purposes, in this document, you're going to decide who you trust to, if you were incapacitated, to file your taxes, to pay bills, to do anything financial for you if you were unable to do so for yourself. And there are a couple of different kinds you can have. You can have the kind that kicks in automatically. So I do have some clients who are out of the country for several months at a time, and they want to make sure that they have a power of attorney that does not even require you to become incapacitated. They have their brother on, if they're out of the country, the brother can go and do something with respect to this person's finances. You can also have the kind that becomes effective, as I stated earlier, if two doctors, let's say, state that you are unable to take care of your financial affairs, and that's called a springing power of attorney. So once again, assessing the people in your circle, deciding what type of power of attorney you want is completely in your control and in your hands. All of these documents can be changed, revoked at any time. So let's say you put someone on right now, and then in 10 years, you have a falling out with one of them, or you discover something that gives you an odd feeling about them. You can completely redo these documents, and the most recent one will guide. The important thing is to have something there that fits what works for you now and in the near future. Sometimes people want to have two people and kind of force them to act together. I would say that that's not usually preferred, because if you need to get two people together to sign a document, yes, a lot can be done virtually, depending on how tech savvy people are, but it can be kind of difficult to orchestrate. So if possible, try to choose a main person. If that main person is unable to do the job, and puts in writing, hey, I can't do this, life has brought enough stuff on me right now, I don't have the time for this, there will be a natural default to the second choice of yours. But I try to recommend to my clients not to use co-agents. Obviously, the person needs to be an adult. I would say if you have kids 18, 19, that's a little bit too young. I think it's better to go with maybe a sibling of yours and then maybe an 18 or 19-year-old kid as a second choice. Hopefully these documents won't be needed for a while. So I think that can be a good way to do it. We draft these documents so there doesn't need to be a conservatorship hearing. So if you don't take the time to decide who would be best to do these things for you while you're alive but lack capacity, then your family can move to have a conservatorship hearing, and the court will hear from different people, and they will probably all kind of lawyer up and state why they're best to do these things for you. It's best if you decide for yourself in the proper estate planning documents who you trust to do certain things for yourself. It will save the family anguish and money. So these documents are in place to avoid any type of conservatorship proceeding down the road. For older clients, they can execute a post. It's bright pink. It's basically to alert emergency medical personnel to not administer CPR if they come to someone's home. They'll see that pink form and not give that person CPR, basically. This does not take the place of a medical directive because a post does not address, Alzheimer's or coma days or anything like that. So if you are older and have a post, you also need to have your medical directive as well. If some of you are Kaiser patients, Kaiser frankly has a very good form that they use. It forces you to think about a lot of specificity with respect to medical scenarios. So I would go ahead and pull that down from the website and complete that in front of 2 witnesses or a notary and at least get that back to them so that you have that in place. And that's kind of what the post looks like for mostly older clients. Okay, so we've talked about 2 documents that everyone needs because we're all here and we could become incapacitated. So we all need a power of attorney for financial purposes and we all need a healthcare directive. Most of us will need a will or a trust. A will distribute property, ideally property totaling under $166,000 can be done through a will without a big lengthy probate proceeding. Those of us who are homeowners will need to have a trust. A trust you prepare now, you put your property into it. As you go through life and maybe sell a home, you'll put a new home into the trust. When you pass one day, it will make sure to avoid the probate process that we have here in California. So if you are thinking about having your estate planning done, what to expect is at a meeting is to bring your spouse if you're a married couple. You'll discuss the strengths and weaknesses of people in your family. They may have sent you a workbook prior to the meeting so that they can get a sense of your family dynamics and maybe what you feel like you want to do one day when you pass and who you're thinking of putting into different roles in your life. You don't have to bring account numbers necessarily at all, like for any bank accounts you have. It's just good to have a general idea about how much you do own. Bring the grant deed if you're a homeowner. That really does help the attorney. That attorney will prepare draft documents based on your discussion and any workbook information, and we'll typically send you the drafts, especially now since we're trying not to meet with too many people in person. You'll review the draft and discuss it with your attorney, and then he or she can make changes quite easily, send you new drafts if needed. Once he or she is certain that you like your documents and like the decisions, you'll get together and sign them with the notary and witnesses. The day that you sign them, they're effective. If you executed a new grant deed placing your home into the trust, the attorney will file that grant deed with the recorder's office. And then you just have to plan on revisiting the issues in your documents and reviewing the documents every 3 years or so. I would think that would be fine. And remember to put new assets into the trust. Also look at the power of attorney and healthcare documents too, to make sure that you have named people who are going to be good for those roles and who are probably willing to help you out one day if needed. And these are examples of a couple of people who passed and didn't have the proper estate planning documents in place. So Heath Ledger, he had named his sister as a beneficiary, but had, since those old estate planning documents were executed, had a child, and he passed and hadn't provided for the child, so it was kind of a mess. Barry White was separated from his wife and had a longtime girlfriend and had never changed any estate planning documents. There was a lot of litigation, a lot of money spent on lawyers, and his estranged wife got some of his estate. So anyway, for ease and saving money down the road and maintaining the harmony in your home, it's best to get this stuff done while you're feeling good and can do so to eliminate confusion and cost down the road. So we can take some additional questions about the second half if some of you have some.
Yes, there are some questions. Let's see, one that you've answered was about the Kaiser form. Was it the same as the Advanced Healthcare Directive?
Yeah, Kaiser does have a good healthcare directive.
Yes.
Yeah, so if those of you who are Kaiser people, I would go ahead and pull that and start thinking about those scenarios and name your agent. And I think there's a setup where you can either have it notarized or sign it in front of two disinterested witnesses. Either is fine for them. So just go ahead and try to do that and then the best way possible these days and get it back to them.
Another question, if the deceased person decided to give his or her property to the children, but she was receiving medical, let's see, they're worried about the house if it even if there was a will.
Yeah, so you want to be upfront with your attorney about that. If let's say there were two kids, it depends on what you want to accomplish. If you do want the person receiving medical to be able to stay in the home, forever, it would affect the benefits probably, because some of those benefits, well, it can affect some kinds of benefits. But once again, it depends on what you want to accomplish for that child. An attorney can set up a special needs trust within a trust that I've described, which would not give that person an ownership right in the property. So once again, that child would not have any assets in his or her name, but would have access to those assets in that the successor trustee could dole out the assets to supplement that person's life and not have it affect the benefits. So there are things that attorneys can do for people like that.
Okay.
In that situation.
If you have a trust, can we get it titled within the county ourselves?
So if you have a trust, I think what they're saying is you don't file a trust in the county, because remember earlier, it's a private document. Right. It doesn't need to be filed anywhere. I think what this person is saying, what you would file with the county is you would prepare a grant deed. Let's say you own your home as community property with your spouse. You would convey it to yourselves as trustees of the Jones Family Trust. Sign the deed, make sure it's properly done. I don't know how savvy you are. I mean, if you're a realtor or something, you could probably do this on your own. And you would file that deed with the county to reflect the fact that you and your spouse or you yourself own your property now in your trust. And that's okay. You can do it yourself if you know what you're doing and take that language verbatim off of an existing deed into a new deed.
And it's sort of like the trust then, the owner of the property is the trust. Is that kind of correct?
Is the trust, but the people, so you are
trustees of trust.
Right. Yeah, so they are trustees of the Jones Family Trust, but the trust is just kind of you. It is you. It's just a different version of you. So instead of owning the property as community property, you'll own the property as trustees of the Jones Family Trust. Doesn't change any property taxes or anything like that.
Yes. Another question. If a person with progressive dementia wants to assign an agent for the healthcare directive, but does not want to sit and discuss and sign the forms, what can be done? I mean, that's a real, that's a real thing to.
It's tough at this stage, because if they do have dementia, if they don't have the ability to execute any legal documents, they can't make those designations now. We kind of missed the boat. So if someone comes in and they've been diagnosed with dementia already, they really according to the law, can't make the best decisions for themselves, can't properly execute estate planning documents or any legal documents. So you would typically have to have a conservatorship hearing
Yeah.
or
So,
apply for that. Yeah.
yeah. Is the person in charge of I imagine it's the trust or whatever the trust, if the person, I don't understand this question exactly, but they're asking about the responsibility to pay bills after the death of a person if they
Yeah.
don't have any assets. So,
If they don't have assets,
yeah.
well, if they don't have assets, they are not anyone named as successor trustee or an executor in a will. It has no personal obligation to pay it out of their money. So if there's nothing left, there's just nothing left, and you have to let the creditors know this person passed away. There are no assets here, but you're not going to be personally liable for any of that.
Okay. What if a parent lives in another state and they want to develop a trust for their children in California? Are there any things to consider there?
Yeah, no, they just need to go to an attorney in their state of residence and
just
complete estate planning documents there, and then they can include property here into those estate planning documents.
Right. Okay, and you answered this about working with a lawyer to update I always think it's a good idea because these are things that are not, you just want to make sure they're done properly. So
right.
I think that's why Hera is so awesome.
Thank you, Beth. Yeah, I think it's good. I mean, if you've already drafted documents and a lawyer did that for you 8 years ago, oftentimes they will do kind of a free 20-minute review with you just to make sure that your decisions still work for you. And then if it seems like things need to be changed, of course, they're going to charge for new work, for new documents completed. But especially if you're going to amend and change things, I think that is too hard to do yourself. So that's a good time to go to a lawyer if you've created a trust and think that you need to change and amend those documents. So but if possible, try to go back to the lawyer that you originally worked with, and hopefully a little bit of that will be gratis.
So a couple more. One is really quick. Are businesses included in trusts?
So if you own a business, you would typically assign your interest in the Jones LLC to your trust. Or if it's interest in a corporation, you would assign that, because if you pass away, we want to make sure that if there's $170,000 of value there, that there's not going to be a probate. So we would typically assign those to the trust. It doesn't change the way in which you conduct your business now, but if you were to pass, it would go through the trust. Okay,
that's good to know. If you have a property that the spouse is not included in the deed because of credit purposes, so you've already maybe asked this, what would happen to the property if you, the owner, becomes incapacitated and there's not a trust in place?
So if you own the property, you're incapacitated.
The spouse does not own the property. They're not on the deed or anything, but you don't have a trust.
Is that spouse not on the deed incapacitated, or is this person incapacitated?
No, the person is incapacitated.
The person, okay, the person who's doing, okay.
The owner, yeah.
Oh, so if that person is incapacitated, first someone would look to see if there is a power of attorney designating someone to handle finances, titling, all of that for that person. If they're incapacitated, and that designee would need to do things for this incapacitated person. But if they're already incapacitated, they can't now execute documents.
Right. So it probably needs to get a conservatorship kind of.
Right. But if the spouse, if they're married, it would typically just default to the spouse. So it shouldn't be too messy in that situation.
Okay. It's a good time to call Hera. I think that's pretty much, we will have this video available. It is a lot of information, and it does, I sort of hear part of it and then I start thinking about it as you continue to talk. So it's the kind of thing where people do need to hear a lot. What if a business isn't an LLC, but a sole proprietorship?
You could do the same thing and assign your interest. Yeah, it kind of the same drill with that. You would assign your interest to the trust.
Great. So the other let's see, if people have other questions, I think I've gone through most of them. But if anybody has any other questions that they have, I would advise you could raise your hand because we do have some time. I think you're through all of your materials. Is that right, Kendra?
I think so. Oh, yep, I think so.
Yeah, so if you want to raise your hand, we can unmute you and you can answer your question. All right, I see Otis. Hi, Otis. Let us allow you to talk if you have a question.
Can you hear me?
Yeah, we gotcha.
Okay, hello everyone. Yeah, I was wondering, what is the turnaround time for an appointment once you call into HERA?
You'll call in, Otis, and then we have intake people that will need to get some preliminary information from you because again, we're a nonprofit, so we just have to do a little bit more background work with clients when they come in. And then they will set up a time for you to speak with an estate planning attorney. There are two of us here. And once we speak with you and then send you a workbook, once you get that workbook back to us, it typically takes a couple weeks to get some estate planning drafts to you. If you own a home, it's great if you can find that old grant deed to your home and send it in when you turn in your estate planning workbook. But yeah, a couple weeks or so.
Thank you.
You're welcome.
All right, anybody else have a question? You can put it in the chat or you can raise your hand. We can unmute you. Any other questions that you have that might have? Okay, I see Simone. You should be able to unmute yourself. Simone.
Yes, I have a quick question. Hi, I have a quick question. If you can't find the grant deed, can you still go ahead and do the living trust and they can find something later, or how does that work?
Yeah, Simone, you can create your trust. At the same time, I would probably encourage you to try to contact the county. Your grant deed is filed with the county. It's just nowadays taking a little longer to get it. So you can frankly go ahead and execute all your documents. And then once that grant deed comes in, we can prepare a new grant deed, have you sign it. If it's just one document for notarization, I mean, you could get it notarized anywhere. So it doesn't stop the process to go ahead and get started. Those two things, obtaining a grant deed and working through the workbook and working through your attorney, can be done concurrently.
Yes, because I've contacted the county, but of course, because of COVID, I can't get in, and it's prolonging me doing my mother's living trust. So should I just go ahead and do it? And then, like you say, once we get whatever we get, then we just go from there.
Yeah, yep. I would say that's better than not doing anything. Absolutely.
Thank you.
You're welcome.
All right, anybody else have a question? One of the things I will just suggest to people is that if you have elders in your family or in your world, start talking to them. As hard as it is sometimes, look for an opportunity to say, hey, I just want to know if something were to happen to you, I want to be most helpful in following your wishes. And sometimes physicians will have that conversation with families, but not always, or with parents. I know we were lucky that the doctor with my parents brought us all in and had us have a conversation. And for a while, there was a whole movement in Alameda County where people were having conversations about, I think they called them actually death cafes. So it was great to have this opportunity to think about, okay, what gives me joy in my life? Do I want to live if I can't eat or taste or put my arms around somebody or breathe on my own? So I would just encourage people it's a hard thing to do, but to have that brave conversation about what gives you meaning in life for families. So anyway, that's my little piece of advice. And somebody asked about what does Prop 19 have to do with getting deeds and trusts set up? I don't know about.
Yeah, so Prop 19 changed the property taxes that kids will need to eventually pay on inherited property. So if kids inherit a home in which they're going to live, they get $1 million exclusion. So let's say parents bought the home for $200,000 and now it's worth $800,000. Mom and dad passed away. Well, if the child files an affidavit stating, hey, I'm going to live here, the property taxes won't change because it's going to be that child's personal residence. With respect to rentals, though, it used to be where if kids inherited rental property, they got the property taxes of their parents. That is what's going away. So it's going to cause, I think, kids who are inheriting property in which they're not going to live, it's going to cause those kids to probably just sell those properties because they won't want to necessarily pay the high property taxes because you'd have to probably increase rents to cover those. If you're going to sell a house anyway, it's really not going to affect you. If you're going to inherit a house and sell it anyway, it doesn't matter because you're not going to pay the new property taxes. Some people are just kind of in a frenzy and all of a sudden putting kids on deeds, and you're giving up certain things by doing that now instead of waiting to inherit something at death. So again, it's a question that you need to speak with not even just a lawyer about, like a tax person about, and figure out the basis in the property at death, basis at the property, you know, of the parents, like their purchase price 20 years ago, to figure out whether you need to all of a sudden put someone on the deed in this last 10 days before it goes into effect. It's a very important decision, and people should not willy-nilly be putting people on deeds.
And I would assume it's like someone asked, when does Prop 13 on rental filing change? So has that already happened?
It's on, well, they chose a day that's actually a weekend. So
Okay.
if it's going to be the Friday before, it'll be the 12th, I think. Anyway,
Of
February. So it's
February.
really just like,
Okay. So
you know, but it'll probably be the 16th on that Tuesday.
Okay.
That
It's
follows.
happening. Okay,
Yeah.
so that's happening now. Someone asked that I have a home overseas. Can I include that in my trust?
You can't, because we would not have jurisdiction of property in another country, and you wouldn't want to necessarily put it into your California trust, I don't think.
Okay.
So I would check with the entity that handles distribution at death in the
Okay.
county where the property is situated overseas. Oftentimes other countries have, frankly, an easier mechanism than what we have here. Sometimes
Yeah.
it's just a matter of filling out forms there. You put them on file, someone passes, it automatically goes to the children.
Right. Is there a cap on the percentage or percentage cap on the property tax raising? Or is it just go straight up to what is
It
correct?
goes up as if you had purchased a new home.
Wow. Okay.
Yeah,
So
unless
there
it's
you
the
go.
primary residence of a child.
Right, of a
and then
child,
you get this
right.
$1 million exception.
Okay. All right. All right. I'm not seeing any other raised hands or questions coming through. So going once, we'll just see if I missed anything. Yeah, this has been really helpful. It can feel like an overwhelming process. I know I did one, and I'm glad I did. And now I'm realizing I need to go update because I have had some changes in my life. And so this is really helpful. Everybody, I'm so glad you're here. We will be putting this training on our website, on our YouTube channel. So I want to thank you so much, Kendra, for your time today and letting us have our questions answered, and appreciate you so much in today for being here with us. So thank you everyone for attending.
Yes, thank you.
Yeah, thank you everyone for attending. I just put a link to our YouTube channel for First Five. We have lots of trainings there that you can go and see. Someone said, this is awesome. Being a trustee for my mom was overwhelming. This would have been so much more helpful then. So that's great. Thank you for,
Good.
appreciate those comments so much from all of you. And that's great. So we love when Hera comes to present. Yes, we do too. We love Hera. So thanks everybody. It is Friday. I hope you all have a nice weekend. The weather's supposed to be nice. So get out safely and have some fresh air. And I hope you do too, Kendra. And I guess I can turn on the camera here. And we'll look forward to seeing all of you at another training soon, I hope. And so happy you're all here.